dated the 23rd day of February. And that we wish to confirm, Your Honor, the said officer is
126 Corporal Jones Nyangige Matthias, currently attached at DCI Parklands, performing investigation duties, Your Honor. Your Honor, I'm the investigating officer for the case of stealing, which was reported at Parklands Police Station. Vide OB number 28 of 8th of September 2025 by the complainant one Bett Kipsang, Your Honor. Your Honor, the complainant alleged that on the 7th of September, he went in one of the restaurants known as Blah Blah Club, which is within Westlands sub-county, Your Honor, at around 3 a.m. for the refreshment, Your Honor. Your Honor, while in the club, at around 4 a.m., he noted that his mobile phone has been stolen, was missing, Your Honor. He made a report to Parklands Police Station. Your Honor, the investigation started. To that lead, Your Honor, the 3 respondents who are before this court, Your Honor, were arrested, Your Honor, for the reason that the complainant, his phone was stolen, and immediately the phone was stolen, Your Honor. Phone that was using mobile phone number, Your Honor, may I read it for the court? 0720 961 143, Your Honor, which is registered under his names, Bett Kipsang. Your Honor, also the same complainant, he's a holder of bank account KCB of, in total he received 500.
500 out of
1.1 million 640,000.
So he received 500,000. That is your allegation. He received
Yes.
500 shillings.
Yes.
Out of 1.6.
Yes.
1.6.
Exact.
Now, paragraph 10. Paragraph 10 of your testimony. You are saying he was arrested at Kahawa Wendai, right? And you recovered one laptop.
We recovered I said we recovered laptops.
Read your supporting affidavit.
We recovered laptops.
What did you recover? One laptop. That is what your supporting affidavit says.
SIM
right?
cards.
Sorry?
SIM cards.
I'm asking specifically about the laptop.
Yes.
One laptop.
Yeah.
Is it unusual to recover one laptop?
May I explain for you further?
Just answer the question.
There is a reason why I recovered.
Is it unusual, that is the question, is it unusual to recover one laptop from one person?
Yes.
Unusual
Because may I respond to you?
Okay.
The reason why I recovered the laptop, if you see the transaction,
Are you
the first transaction, immediately the line was activated. The money was sent to the
Your Honor,
third respondent.
is it unusual to recover one laptop from one person?
Yeah, if it is there,
It is unusual to recover one laptop from one person.
yeah, it is what I've got. And it is linked to my
Everyone
case.
has one laptop.
Yeah, but there is a reason.
All right. Now, you are also saying that you recovered some SIM card templates from the third respondent. How
Yes.
many?
There is.
How many?
Their SIM cards
Do you
are,
say that in your supporting affidavit?
yeah, I
You
mentioned.
don't. You don't.
I mentioned.
You have said.
Check there, I
You
wrote
have said
SIM
the third
cards.
respondent, hold on. The third respondent was arrested in Kahawendani area in his rental house, where the recovery was made, one laptop and some SIM card templates. You have not said the number.
I didn't say
You did
indicate,
say
but
No,
I
you
shown
have
the
that
to the
very
affidavit
simple.
that I recovered the
Don't
SIM
make
card.
it difficult.
Yeah, I
You did
recovered
not
SIM
say
card.
SIM card, yes. not
Yes.
SIM card.
Yeah.
From the third respondent.
Yeah.
So at this point, you're not telling the court the number.
No, I didn't
You
give
did
out
say-
the number. Yeah.
And you are also saying that it's just one.
Not one, SIM cards.
Oh, one laptop, that is so.
One laptop.
One laptop
Yeah.
and SIM card claims.
Yeah.
And thereafter, the other nexus to him being there is 500 shillings out of 1.6 million.
Yeah. Because this is an organized crime.
No, hold on.
This is an
Let's
organized
answer my
crime.
questions.
Yeah.
It's fine. You can do your repertoire in the internet.
Yeah.
500 out of 1.6 million. Just
He
for that-
received without the consent of the complainant.
Now, paragraph 14, releasing the court, releasing the respondent, I want you to focus specifically on the third respondent, right? He may interfere with pending or ongoing investigations.
Yeah.
How?
Because the reason, if you may check the first activation of the SIM card of the complainant,
Yes.
and the first transaction
Yes.
which was done was to his mobile phone number
Now, when was this crime committed, allegedly? When was the alleged crime committed?
on 8th
On 8th
September
of September
25.
2025,
Yeah.
last year.
Yeah.
How many months ago is that?
Around 4,
Around
45. Yeah.
Do you have any evidence that he has interfered with the investigation?
He can, yeah.
No, you don't have that he has.
I have that
you
evidence.
You are saying he can.
I have that
You
evidence.
have that evidence.
Yeah.
Have you supplied to the court? Do I have it in your application?
And that's why I'm seeking this.
No. Do I have it in your application?
In my
You-
application,
You're familiar with paragraph
I'm
Article
seeking
49.
days for the
Don't-
investigation to be completed.
Don't You're familiar with Article 49, 1H of the Constitution, right?
Yeah.
It is the reason why you are applying for this application.
Yeah.
It is the basis in law that you are applying for this application.
Yeah.
It says compelling reasons, right? And you are saying that you want this court to detain him for 10 more days.
Yeah,
and you are
exactly.
saying you have that evidence, but you have not submitted it to the court at this point. Do you understand how absurd that sounds? Do you?
Your Honor, did he has a consent from the complainant that he sent him those cash?
Ayo, he received 500 shillings.
Yes, from who? From who?
He did not control. Does he control the people he received
What was the
money?
motive of immediately he received money, he transferred it to another SIM card? What was the motive?
I think that you do not ask the questions. I do ask the questions. Your Honor, I think that will be all for me.
The investigating officer has submitted that the respondents were arrested yesterday from different locations and from rental houses, and stated that the same may pose a challenge to him, and also stated that the said witnesses may interfere with the investigations. He has also stated that he requires time for investigation of the said SIM cards together with the mobile phones and laptop required from the respondents. This application has been opposed by the third respondent through counsel, Mr. Okello, who has submitted that the investigating officer has not placed any tangible evidence before court to show that the third respondent may interfere with the witnesses. He has also told the court that the accused persons will not be required through in the investigations that will be going on for the forensic analysis of the SIM card and the laptops, and also stated that the third respondent has a personal matter which he intends to attend to, and prayed that they be granted bond. He relied in an authority which stated that where the rest suspects are not required for purposes of investigations which are ongoing, then it will be prejudicial for them to be retained in custody while the investigations were going on, and prayed that the third respondent be released as his family members were before court. The second and the first respondent had no objection to the orders, save that they prayed that the said dates be reduced. In concurrence with the investigating officer, the prosecution also insisted that they be allowed to have the said application allowed, and the alternative that stringent orders be given so as not to interfere with the investigation. In my analysis, I have considered the application and the objection raised by the third respondent and the response made by the second and first respondent and that of the prosecution. I will agree with Mr. Okello appearing for the third respondent that nothing has been placed before court to show that the three respondents are of flight risk and that they would interfere with the investigations and how they would help in the investigation of the said forensic analysis. The role of the court is to balance the rights of the suspect and that of public interest on matters of justice. Therefore, the application to have custodial orders for 10 days will be prejudicial to the respondents who are before court, since there is no evidence seeking the same. Therefore, the court will allow the application, will decline to allow the application and direct that the respondents herein will be released on a bond of Kenya shillings 200,000 with a surety of similar amount, or a cash bill of 50,000 each with 2 contact persons. They'll be directed, the court will further direct that they will respond to summons issued to them by the investigating officer for purposes of investigations. They will also be allowed to have legal representation in the conduct of the said investigations. We'll have a mention after 10 days to confirm the progress of investigations.